My name is Arameh Vartomian, and I have the honor of moderating this panel discussion with three distinguished speakers today. The panel is titled Corporate Responsibility for Human Rights and Humanitarian Abuses. As I mentioned, we have three distinguished speakers, one of which is remote, Miss Mary Hansel. She's an attorney and legal scholar based in Los Angeles. She's the acting director of the International Justice Clinic at UC Irvine School of Law, where she also directs the Human Rights and Social Media Initiative. She has taught both clinical and doctoral courses on international law and human rights. Prior to academia, Ms. Hansel practiced commercial litigation and international arbitration at private sector law firms. She has extensive experience working on human rights matters at NGOs, including Human Rights Watch and International Center for Transitional Justice. She has also consulted international criminal law issues for proceeding before the High Courts of Uganda. Ms. Hansel has earned her JD from University of California, Southern California, Gold School of Law, and her master's in public international law at London School of Economics. Welcome, Ms. Hansel. Our next distinguished speaker here with us in the panel is Genevieve Zingg, who is a board member at Yazidi Legal Network. She's a Canadian researcher, and she has developed a particular focus on war crimes, extradition, economic sanctions, and international justice efforts. She holds a graduate diploma in law from City University of London and master's in international human rights from Columbia University in New York, where she has specialized in human rights in context of national security, counterterrorism, and armed conflict with regional focus on Middle East and North Africa. Mrs. Zingg has substantial experience working with refugee communities in Greece and has previously conducted human rights fieldwork in Turkey and Palestinian territories. She's a research affiliate of the Canadian Network for Research on Terrorism and Security and a member of International Bar Association. Welcome. And last but not least, a dear personal friend of mine, Sharmagh Mardi, a brilliant lawyer here based in Yerevan, Armenia. Sharmagh throughout years has been involved in many humanitarian activities, but after the recent war in Nagorno-Karabakh in 2020, she is more determined to initiate steps to fight for truth and justice and protect vulnerable persons from the effects of armed conflict. Her work aims at presenting these individual stories to international community. And speaking from personal experience, I have to say Sharmagh has a very bright future in front of her. So welcome, Sharmagh. I've been told that the only job that a moderator has is to keep the time. So I'll be doing that. Sharmagh will have 5 minutes. Miss Zingg and Miss Hansel will have 20 each. And I will be very strict on time. And at the end of the discussions, we will have 20 to 25 minutes for Q&A. And I believe there are pens and papers here that you can write your questions and send it to me. There you go, Mariam is showing to you right there. Okay, with that, Ms. Hansel, you can start. And Sharmagh starts now. I apologize. Sharmagh's 5 minutes starts now.
Thank you. So, hi everyone. Today I'm going to talk about command responsibility and whether Azerbaijani military commanders and or other superiors should bear criminal responsibility for war crimes committed by their subordinates during the 2020 Artsakh war. So international criminal law states that military commanders and or other persons effectively acting as such shall bear criminal responsibility for crimes committed committed by their subordinates under their effective command and control or effective authority and control if they knew or based on circumstances should have known that their forces were committing or about to commit such crimes, and they did not take all necessary and reasonable measures within their power in order to prevent the crime or to punish the perpetrators. if such crimes had been committed. There are many examples of war crimes committed by Azerbaijanis. The numerous videos circulated on social media during and after the war show the brutal treatment towards Armenian soldiers and civilians by the armed forces of Azerbaijan. And based on the international case law on command responsibility, it can be concluded that the extensive amount of videos actually are evidence that Azerbaijani military commanders and or other superiors had knowledge, yet they neither prevented nor punished the perpetrators. Azerbaijani armed forces also deliberately attacked Khazanchetos's cathedral located in Shushi. The attack was not a mistake. It was intentional, as the cathedral was hit not once, but twice through airstrikes. Thus, it's without question that an order was given to commit such a crime, and that should lead to the criminal responsibility of those responsible for the strikes. Further, based on the testimony of a captured mercenary, Azerbaijani and Turkish commanders gave mercenaries orders to kill every single Armenian they encountered, and promised to pay them a $100 bonus for every beheaded Armenian. This is actually direct evidence of various commanders' knowledge of such criminal activity. According to international law, a commander shall also bear criminal responsibility when he notices the inhuman and degrading treatment of his subordinate towards a POW and does not do anything in order to prevent it. Based on the testimony of a repatriated POW collected by Center for Truth and Justice, a high-ranking officer had witnessed the mistreatment of his subordinates towards Armenian POWs and did nothing. However, it's also important to mention that identifying the Azerbaijani commanders responsible for the mistreatment of Armenian POWs actually poses a challenge. And this problem is due to the repatriated POWs' difficulty in remembering the names, ranks, and other identifying information of those responsible for their mistreatment. In conclusion, many Azerbaijani military leaders shall bear criminal responsibility for war crimes committed by their subordinates during the 2020 Artsakh war. As they had effective control over their forces, they knew or should have known that their forces were committing or about to commit such crimes, and they failed to take all necessary and reasonable measures within their power in order to repress, prevent, or submit the matter to competent authorities for investigation and prosecution. And whenever the human cruelty crosses every possible line that refers to respect for human rights, the strict punishment shall come into play in order to recover justice. So thank you for your attention. That's all.
Thank you very much, Sharmagh. I forgot to mention that Sharmagh is a CFTJ trained student lawyer, and she's now full-time staff who is training the next generation of Armenian lawyers. Thank you, Sharmagh. Next. Yes. Next, let's have Miss Hansel. Hello.
Hi, I can see how enormous my head is on the screen. So I've turned it off when I'm not speaking, but should I show my slides or are you able to do it from there?
You could show your slide. You can share it with us.
Sounds good. Great. So thank you all so much for including me in this important event. My name is Mary Hansel, and I'm an international human rights attorney specializing in business and human rights, among other areas. It's 11 p.m. here in Los Angeles, and I'm tucked away in a corner of my house and maybe speaking more quietly than usual so as not to wake a sleeping child, but please let me know if you're having any trouble hearing me. I've been invited to speak today on the general landscape for corporate accountability under public international law. I'm going to cover some high-level basics with the understanding that my co-panelist Genevieve will drill down into some specific case studies. The topic is, of course, timely, given recent events, from Elon Musk possibly taking the helm at Twitter in order to control online expression, to H&M leaving Russia in response to the Ukrainian invasion. Okay, so a quick overview of my presentation. What I'm going to I'm going to begin by teasing out the conundrum of business accountability for international human rights and international humanitarian law abuses. Then I'll provide some examples of business impacts on IHR and IHL. Then I'll move on to discussing public international legal bases for business accountability, and then conclude with a few advocacy strategies. So 2 quick caveats. Given our time constraints, I'm going to focus on global instruments and not spend much time on domestic or regional laws. And secondly, some of what I'm going to cover may be familiar to many of you, but my understanding is that our audience members have varied backgrounds with respect to IHR, IHL, and corporate accountability, so I'm going to try to cover my bases. Let's start by situating this issue. Those of us who work in the field of corporate accountability can take for granted the underlying premise of this panel, that companies owe obligations under public international law. Yet this proposition is still a rather envelope-pushing, non-straightforward, and controversial one. This is largely due to the fact that the contemporary public international legal system was designed to govern states as its primary subjects. States ratify human rights treaties and are the subjects of non-treaty instruments such as UDHR. They also create and are bound by customary international law, although there's some discourse about whether non-state actors have a role to play in its formation. They hold positions with important lawmaking UN bodies. Generally speaking, states are the entities that are litigated against before the ICJ, which is the UN's principal judicial organ, as well as most, if not all, regional human rights courts. Significant exceptions to public international law's state-centric nature do exist. For example, IHL can apply to non-state organized armed groups as well as states, and ICL, of course, has natural persons as its primary subjects. However, at base, the public international law system was simply not designed to directly govern companies. At the time the system as we know it today was created in the wake of World War II, companies did not hold as much sway on such an enormous scale as they do today. But nowadays, and for the past few decades, if we're thinking in terms of which global actors hold tremendous resources, or in terms of which actors wield unprecedented power, or in terms of which actors have pronounced impacts on human rights, then we need to think about corporations and what their concomitant responsibilities should be. Over the decades and accelerated by globalization, private companies have become more and more influential. One sobering indicator of this is that of the 100 largest economies in the world, 51 are corporations, only 49 are countries. So, company involvement in human rights and humanitarian abuses in one form or another is pervasive. Let's take a look at some examples to get a sense of how intricately linked business activities are to common human rights and humanitarian abuses. So the first example with respect to the international human right to self-determination, which is described in the left-hand column, business activities implicating this right include conducting extraction of oil, gold, etc., on land with traditional significance to the peoples that inhabit the area, and supplying lethal injection drugs for the execution of a Native American despite tribal objections to the death penalty. With respect to the human right to life, business activities implicating this right include using arbitrary lethal force as a provider of private security forces contracted by a state, and operating in ways that pose life-threatening safety risks to workers or communities. This can be through exposure to toxic chemicals or manufacturing and selling products with lethal defects. With respect to the human right not to be subjected to slavery, servitude, or forced labor, business activities implicating this right include transporting people or goods in ways that facilitate the trafficking of individuals, or unknowingly or with willful ignorance, benefiting through supply chains from the forced labor of workers. With respect to the international human right to freedom of opinion and expression, business activities implicating this right include censoring online content pursuant to a state demand not in line with human rights standards, and bringing litigation against workers or other stakeholders who have spoken critically about the company, where there's an imbalance in the party's means to fund a legal case. And with respect to international humanitarian standards, business activities implicating these standards include facilitating the killing of civilians while serving as a private military contractor in an interstate armed conflict, which, as I mentioned, also implicates the right to life, and listing and promoting rental properties and hotel rooms owned or run by settlers in settlements in occupied territories. These examples, of course, are all based in real life. So as you can see, companies have involvement in a broad array of human rights and humanitarian abuses. In fact, these days it's difficult to imagine such an abuse that doesn't involve some sort of business activity facilitating the abuse. So now that we've identified the legal lacuna for companies, as well as their diverse and outsized influence, what are the options for pursuing accountability? And before we jump into this, I just want to give a brief note on what I'll call corporate DNA. One reason it's so difficult to secure accountability for corporations and to induce responsible business practices is due to the unique type of entities that they are. I think there's a popular narrative that applying public pressure on companies, appealing to their CEOs, better angels, will bring about the accountability we're looking for. But is the greediness, the moral failings of heads of companies the problem here? Over 50% of all publicly traded companies and most Fortune 500 companies are incorporated in the US state of Delaware. Pursuant to longstanding Delaware law, public companies have a heightened legal duty to maximize shareholder profit. In 1970, Milton Friedman once pronounced that the sole social responsibility of business is to increase profit. And legally speaking, this is largely still true today. This means that if changing business activities to align with human rights or IHL conflicts with this duty, a risk-averse CEO will choose profit unless they can make a case to shareholders that the change will bring about short-term loss but long-term profit. But many CEOs are not even going to want to take that chance that they could face a shareholder lawsuit, given the high cost of defending such lawsuits. Even winning at trial could be a Pyrrhic victory. I mention this not to justify any corporate abuses, of course, but rather to elucidate what kinds of actors we're talking about here and what their sort of raison d'etre is, pursuant to binding US law. I think this understanding is missing from many discourses on business and human rights. And from an advocacy standpoint, I encourage more engagement with the myriad proposals out there for reforming US corporate law to better incentivize adherence to IHR and IHL standards. Because if we're thinking systemically, and I think we should be, then I do think this should be on our radar. So with that said, onto our international legal bases. There are effectively two main non-exclusive approaches for pursuing company accountability for abuse. First, via state obligations, and secondly, direct company accountability. I'll briefly discuss some of the main legal bases relevant to each approach. So via state obligations, in some ways, this is the easier of the two routes to accountability because state obligations to protect human rights from interference by companies is well established. First, states are required to respect, protect, and fulfill each human right. And the protect prong of state obligations means that states must prevent and redress violations of rights by third parties, including companies. It's not enough for states to just respect human rights, meaning to refrain from interfering with human rights themselves. They have a proactive obligation to regulate interference by others. Second, we have the UN Guiding Principles on Business and Human Rights, affectionately referred to as the Ruggie Principles, after John Ruggie, the professor who oversaw their drafting. For those unfamiliar with the Ruggie Principles, they're a set of non-binding but highly authoritative explanations of state and company responsibilities with respect to business-related human rights and humanitarian abuses. They were endorsed by the UN Human Rights Council about 10 years ago and are really the touchstone instrument on this issue. With respect to states, and I'll address their obligation for companies momentarily, the Ruggies underscore and elaborate state obligations to protect rights and remedy abuses involving business activity. The third legal basis in this vein, and this is a pending legal basis, we have the in progress legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business entities. That is the mouthful of a title of an instrument that's in its third iteration, but eventually will be a binding treaty focused on state obligations with respect to business and human rights. In its current form, the draft treaty sets specific benchmarks for how states are to protect the full spectrum of rights from business activities and the provision of redress for abuses. One thing I love about the treaty is that it really centers the victims of business-related human rights abuses rather than the companies. And it will likely establish a treaty body that will issue general comments and review states for compliance every few years. Anyway, it's still in the drafting and negotiation phase, but I encourage advocates and scholars to watch this space. Fourth, I thought I'd briefly mention one of my favorite general comments, which is General Comment 24 from the Committee on Economic, Social, and Cultural Rights, which goes into elaborate detail regarding state obligations with respect to economic, social, and cultural rights impacted by business activities. This is a great resource if you're dealing with a state that has ratified the International Covenant on Economic, Social, and Cultural Rights. So these are just a few legal bases for holding companies accountable via state obligations. Now we move to a more circumscribed set of options for holding companies directly accountable. Okay. First, even though, as I said, I don't have time to cover domestic legal bases, I do want to briefly mention the US Alien Tort Statute. The ATS was enacted in 1789 and simply provides the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the US. The statute effectively lay dormant from 1789 until 1979 when it was invoked in a case called Flartica. Thereafter, it became a potent tool for direct corporate accountability for a few decades until the US Supreme Court began to chip away at it in a series of decisions, culminating in the Nestle decision last year. The Nestle plaintiffs, who had endured forced labor as children, alleged that Nestle aided and abetted their abuse by cocoa farmers in Cote d'Ivoire. The Supreme Court found for Nestle and its co-defendant Cargill, based on the presumption against extraterritoriality. In other words, not enough of the alleged corporate misconduct occurred in the US. However, the case is an important win in at least one respect. The opinion did not find that corporations were immune from international human rights liability, and several justices emphasized, albeit in dicta, that corporations do have liability for human rights, which is quite remarkable coming from the current justices of this court. However, following Nestle, the utility of the ATS for providing corporate accountability is unclear, particularly for abuses without a really strong connection to the US. Advocates are currently bringing cases to test the contours of this latest decision, so this is another space to watch. So around the time the Supreme Court was chipping away at the ATS, the Ruggie principles were drafted and endorsed by the Human Rights Council, as I mentioned. These principles do lay out state obligations, but they're most well known for imposing direct company responsibilities. However, while states are responsible for respecting, protecting, and remedying, does that say 5 minutes? Okay, got it. Human rights under the principles, companies are only responsible for respecting and remedying human rights, which indicates a less proactive role than states have. Under the Ruggie principles, companies are called upon to respect a broad range of international standards, including those enshrined in the Universal Declaration of Human Rights, the core human rights treaties, and international humanitarian law. To respect IHR and IHL means that companies should conduct human rights due diligence on an ongoing basis to avoid causing or contributing to adverse impacts, as well as to remediate such impacts when they occur. If a company identifies that it may cause or contribute to abuses and that it cannot prevent those abuses, the only compliant course of action maybe not to undertake the relevant activity. I also want to mention that a UN working group has developed a set of principles to frame the Ruggie principles in a gender-sensitive way. These are referred to as the gender Ruggies, and these constitute another important resource. And the last legal basis I'll mention is international criminal law. Corporate liability under ICL is an idea that's been percolating for decades, including during the Rome Statute negotiations. And there's really been increasing acceptance of the idea. There's even some precedent. For example, the appeals chamber of the Special Tribunal for Lebanon held that the court may proceed against a media company, observing that the corporate criminal liability was, and I quote, on the verge of attaining, at the very least, the status of a general principle of law applicable under international law. So as I wrap up, I just want to briefly mention that there are some interesting governance models cropping up in this space. For example, you may be aware that Facebook has an oversight board, which is a form of self-regulation. It's a quasi-judicial, quasi-independent body that deliberates on and decides cases involving Facebook's content moderation. Critics argue that the board is a fig leaf and a distraction from Meta or Facebook, whichever you want to say, human rights problems, but it's worth noting that the board's decision directly apply international human rights law through the prism of the Ruggie principles. And they're creating some really important human rights jurisprudence, and it might be an interesting model for other companies to adopt. So, given CFTJ's focus on advocacy, I thought I'd conclude with a list of advocacy strategies for corporate accountability. These include coalition building, particularly among the stakeholders most impacted by corporate activities, public pressure and media advocacy, human rights reporting, engaging with UN and regional special procedures. I have 1 minute, I can see, thanks. Strategic litigation, shadow reports, calling upon national human rights institutions to promote corporate accountability, engagement with domestic corporate law reforms, as I suggested earlier. And I'd be very interested to hear other strategies from you all. This is a really generative space with considerable room for creative thinking. Thank you so much, and I look forward to our discussion in the Q&A.
Thank you very much, Mary. I believe our next speaker would like to use the podium, so.
My slides. Do I just press this for my slides to come up? Okay. Perfect. Thank you so much. Good morning, everyone. Thank you to Professor Hansel and Ms. Mardi for their excellent presentations, and thank you to the Center for Truth and Justice for inviting us to speak about corporate liability today. When you hear the phrase corporate liability, I know that it might not strike you with excitement. It's not known as one of the sexiest topics in human rights, but my objective here today is to convince you that in fact this is one of the most dynamic, important, and quickly evolving areas in international law. As Mary mentioned, major international corporations today wield enormous power. In fact, they are more powerful than many state actors. And it is therefore imperative that we ensure that they are held accountable if and when they contribute to, facilitate, enable, aid, sustain, or are otherwise complicit in the violation of rights or the commission of international crimes. So I'm going to run briefly through some case studies so that we get more of an idea of how and when corporations are involved in this type of activity. So to begin, many of you, I'm sure, are familiar with the dark and terrible history of the Holocaust. Specifically, you might be familiar with the use of gas chambers. The beauty of corporate liability is to force us to look beyond the direct perpetrators, say, of the Nazi regime, and look further at the wider, broader system that enabled such crimes to occur. For example, If we look through the lens of corporate liability, we are forced to ask the question of who manufactured and supplied the Nazis with the poisonous gas used in those chambers to horrific genocidal effect. Similarly, you might be familiar with the concentration camps where Nazis interned and brutally exploited its prisoners, but corporate liability forces us to ask which companies were actually benefiting from and using the slave labor from those camps. Most importantly, going back to criminal responsibility, do these companies bear responsibility for their involvement in sustaining or profiting from such a system? So during the Nuremberg trials that were held in the aftermath of World War II, there were 3 major industrialist trials that people sometimes forget about, but these trials asked exactly these questions and are often held up as prominent positive examples of proper attention being paid to corporate liability in the context of war crimes and genocide. So for example, the company that supplied the Zyklon B gas that was used in the gas chambers during the Holocaust was a company called IG Farben. This case looked at this private German chemical conglomerate who was responsible via one of its subsidiaries for providing the Zyklon B gas. And they also relied on slave labor from the concentration camps, including 30,000 people from Auschwitz. And they were also involved in medical... Closer to the mic. Sorry. The other 2 industrialist trials of the 3 that I mentioned are the Flick trial and the Krupp trial, both of whom also looked at companies that used the slave labor from the concentration camps, and these trials dealt with the complicity of corporations. I want to make a quick note here of the politicized nature of corporate liability efforts, because this will continue to be an issue for us in this space going forward. As Professor Hansel mentioned, these corporations are obviously very profit-driven, and I want to add to that states are often incentivized to protect corporations that are good for the economy. So there's a really interesting piece for the Boston Review last year in which Erica Eisen noted that in fact there were plans for further industrialist trials to be held in the post-World War II aftermath, but they were torpedoed due to communist versus capitalist tensions between the USSR and the United States at that time. So she writes, the British dropped almost all suits against industrialists. The United States cut its list of possible defendants down by a half, what might have been a serious legal probe into the wartime actions of German industry was reduced to a handful of prosecutions, targeting only those whose crimes were most heinous and most easily proven in a court of law. So that is something in terms of advocacy going forward that we will also have to think about, is how to overcome the lack of political will that we often see in holding major financial institutions, major banks, and major corporations responsible for violations of human rights or complicity in international crimes. So that point is very important when we look at other examples which have parallels to the post-World War II industrialist cases. So for example, we have Hugo Boss and Volkswagen, who today have been implicated in exploiting the enslaved Uyghur population in Chinese concentration camps. So when we see a lack of impunity, we see this behavior continue. So in fact, Hugo Boss and Volkswagen also employed forced laborers during World War II, but it failed to learn from that history, arguably because there was a lack of serious recognition or acknowledgement of their role in sustaining these crimes. Other examples of more direct involvement or participation in human rights abuses include the cases against major chocolate companies such as Nestle, Mars, and Hershey for the use of child labor and slavery, slave labor, which Professor Hansel touched on, which this case was brought under the Alien Tort Statute in the US by former child workers in the Côte d'Ivoire. But in June 2021, the Supreme Court of the United States ruled in an 8-1 decision that the suit should be dismissed, citing a lack of US jurisdiction over the allegations. So another example, also mentioned by Professor Hansel, arises from Airbnb and other corporations' involvement in the occupied Palestinian territories in the West Bank. Airbnb, for example, was widely criticized for listing rental properties on the Israeli settlements in the West Bank, which are widely recognized as illegal under international law. Human Rights Watch, in a very interesting report, found that in the context of settlements Any business activity in this area contributes to and benefits from Israeli violations of Palestinian rights and international humanitarian law. And various reports, this is a Human Rights Council report as well, which discusses how these companies' activities in this area enable, facilitate, and profit from the construction and growth of the settlements. This is a list of some of the examples of how so. This is the UN Human Rights Council report I mentioned. And this is the Human Rights Watch report, which looks at the United Nations Guiding Principles on Business and Human Rights, which obligate companies around the globe to conduct due diligence and mitigate any harmful human rights impacts of their activities. So, moving forward, we're going to look more at indirect involvement, such as financing human rights abuses and international crimes. This is a particularly interesting area to me. You might have heard of the Lafarge case. The Lafarge company is a French cement and concrete producer who is charged with complicity in crimes against humanity over accusations that it made payments to the Islamic State in Syria. There was a new development in this case just 2 weeks ago, as the Paris Court of Appeals upheld a decision from the French Supreme Court to reject the company's application to dismiss the charges against it. So the case is now being allowed to proceed, which means the court will consider whether Lafarge is complicit in crimes against humanity for paying the Islamic State 13 million euros or $17.3 million in order to continue operating their cement plant in Jalabia in northern Syria. So one of the most important elements from a legal perspective to consider about this case is that the court's reasoning with respect to knowledge versus intent. Lafarge has already accepted the fact that indeed its Syrian subsidiary did pay middlemen to negotiate with armed groups, including but not limited to the Islamic State, to allow the movement of staff and goods inside Syria during the period in which the Islamic State was occupying territory. Now, in 2019, as you can see here, the Paris Court of Appeal had originally accepted that these payments were not intended to abet the crimes carried out by the Islamic State. However, on appeal, the court ruled that complicity in crimes of humanity does not actually depend on this higher standard of intent, but can instead be satisfied by knowledge, stating that knowingly paying several $1 million to an organization whose sole purpose was exclusively criminal suffices to constitute complicity regardless of whether the party concerned was acting to pursue a commercial activity. And I would personally add here, because I have a background in the Islamic State, that this group was very vocal and explicit about its objectives from its inception and skillfully disseminated its messaging and propaganda online, which included publishing its intent to eradicate the areas it occupied of so-called infidels, which it concentrated on the Christian and Yazidi minorities, and committed various acts, which it was, again, very public about, including mass executions, torture, forced disappearances, forced conversions, sexual slavery, and genocide. Now, this is really important to note here that this was inherent to the group, and it was carried out systematically and on an ongoing basis, rather than perpetrated by individuals within the context. So, for example, in contrast, you might have a non-state armed group whose sole aim or primary aim, say, is it's created as part of an uprising against the government, say in the context of revolution. In the latter case, the purpose of the group is not inherently criminal, though of course members of that group might individually commit criminal acts. So I think it would be very difficult for Lafarge to argue a lack of knowledge in this case. A very similar example arises in the case of Ericsson. So that's a little bit more about the standard of knowledge. So Lafarge should have known or ought to have known that its payments to the Islamic State would be used to contribute to the crimes being committed. A second example, arises in the case of Ericsson, which is a Swedish telecom giant who allegedly paid the Islamic State tens of millions of dollars, similarly to operate in ISIL-held territory in Iraq, specifically in the city of Mosul. Some members of the affected minority communities in Iraq, sorry, it's freezing a little bit. Some members of the community, particularly the Yazidi community, have asked for Erickson to compensate ISIL victims and have alleged that it too should be charged with complicity in crimes against humanity and genocide. So based on that latest development in the Lafarge case, it would not need to be proven that Erickson intended to facilitate or aid the crimes being carried out by the Islamic State, but the applicable standard, potentially depending on the decision in Lafarge, would be that Erickson knew or ought to have known that crimes were being carried out and that paying ISIL would contribute to those crimes. Again, these payments were allegedly made as late as 2018, and given that there was a wealth of publicly available information regarding and detailing ISIL's crimes, it would be very difficult, in my view, to successfully argue lack of knowledge. So I want to move now to the complicity of big tech in ISIL's genocidal campaign against the Yazidi community. I am here today in my capacity as a serving member of the board of the Yazidi Legal Network, the mission of which is to assist the Yazidi community in achieving recognition of and accountability for international crimes committed by ISIL. As you may already know, ISIL's genocidal campaign against the Yazidis led to the expulsion, flight, and effective exile of the Yazidis from their ancestral lands, the forced sexual slavery of thousands of Yazidi women and girls, the mass execution of thousands of Yazidi men and boys, the forced conversion campaign of thousands more Yazidis, and the displacement of approximately 500,000 Yazidis, the majority of whom are now living in terrible conditions in IDP camps in Iraq and Syria. Thousands more remain missing or are still being held captive by the Islamic State. So much attention has already been paid to efforts to hold direct perpetrators responsible for crimes committed against the Yazidis, and I'm sure that's being discussed next door in the Universal Jurisdiction panel. In particular, cases held in Germany. In Frankfurt, a former ISIL member was convicted of genocide and crimes against humanity for purchasing a Yazidi woman and her 5-year-old daughter as slaves in 2015. But less attention, comparatively, has been paid to Yazidi efforts to hold big tech companies such as Facebook, WhatsApp, Instagram, and Telegram responsible for contributing to the trade of Yazidi women and children as slaves and sex slaves on their platforms. So another Yazidi group, the Netherlands Help Yazidi organization, has demanded an international investigation into the role that big tech platforms played in the genocide of Yazidis. They published recently a 120-page report evidencing how the trafficking of Yazidi women and girls was facilitated by these tech platforms. And we can see a little bit about how, and this is very important, but they were actually warned, and the examples or usages of their platforms in this respect was brought to their attention, and nonetheless, they have done very little about it. So Global Witness, an NGO, actually tested this after the fact by posting fake trafficking ads, and those were still able to be published despite Facebook's commitments to end these practices. So this is another example on Facebook of a direct advertisement for a Yazidi slave. And there were hundreds of those. As you can see, Twitter and Facebook did not respond to requests to remove materials such as auction pages selling Yazidi women. So it's not that these organizations and platforms were not aware. They were made aware repeatedly and did very little about it. So the Yazidi efforts to hold big tech accountable for the critical role these platforms played in recent genocidal campaigns mirror similar efforts made by the Rohingya population of refugees in California. So in December 2021, a class action suit was brought by a Rohingya woman in Illinois on behalf of the 10,000 plus Rohingya refugees who have recently resettled in the United States. The suit was brought against Meta, which is Facebook's parent company, alleging that Facebook's algorithm amplified hate speech against the Rohingya people, in turn contributing to the persecution and alleged genocide of the minority community in Myanmar. The suit also alleges that Facebook neglected to remove inflammatory content despite repeated warnings that such posts could foment ethnic violence. So again, if we know about genocide, we know that there are 10 stages, some of which includes the dehumanization of a certain group, incitement to violence, organization and preparation, which can include organizing the sales or auctions or trafficking of, for example, the Yazidi women, discussing and negotiating payments and physical transfer of women and girls, and so on. So these actions were facilitated the stages of persecution and extermination integral to the commission of genocide, and arguably were helped considerably or facilitated by platforms like Facebook and WhatsApp. So as Mary mentioned, as Professor Hansel mentioned, these cases are ongoing. They force us to confront important questions head on about how these crimes and human rights abuses happen. These don't happen in a vacuum. They are often sustained and enabled and facilitated by the broader network of corporations acting in tandem with the groups committing these crimes. In terms of advocacy strategies, I think that there is a really good opportunity for impact and strategic litigation in this space going forward. And I think as we see the growth of the concept of corporate social responsibility, for example, in the environmental sphere, so many of you might be familiar, for example, with new commitments being made by companies like H&M or Zara on the environmental and sustainability front. And I think that there's a good nexus there for us to also include commitments made by corporations with respect to human rights abuses and their role in potential international crimes committed by armed groups like the Islamic State and others. Thank you very much for your time today, and I look forward to discussing further.
Thank you very much. It seems like we are good on time. So we have a bunch of questions and we will try to have all of them answered by our experts. Can we have Professor Hansel to be on this in here? Okay. Here we go. Let me find my questions. So the first question is not addressed to any specific speaker, but it asks, as hypothetically, if a US-based company sells microchip to an overseas state that incorporates them in military drones, which are used to kill and injure citizens in a war of aggression, under the US law or under the international law, do the foreign injured citizen have a recourse in the courts, specifically in the US, but maybe in the international courts? Professor Hansel, everybody's looking at you, I think. You are the expert on it.
Okay. I'm not sure I caught all the details of the hypothetical, but from what I understand, do they have recourse in the US is the ultimate question. And I think, you know, the first option that comes to mind is the Alien Tort Statute. I think it would depend on how close the nexus is between the harm and the activities and the US, but I think it would be a real uphill battle. There might be some domestic statutes that the plaintiff could take advantage of, which isn't really my area of expertise, and that of course would be heavily dependent on whether they could meet US jurisdictional requirements. But yeah, I defer to Genevieve for her thoughts.
I think the Alien Tort Statute as well would be the greatest example in the US situation. In international courts, I think one of the issues is that the US is not a party to many of the courts that we would otherwise look at. So I think, unfortunately, recourse for justice would be limited in that sense.
Okay, perfect. We are talking about the corporations, and the social media and tech companies have a very highlighted role in what's happening at all these human rights abuses. overall. So one questioner asks, has there been an example of social media platform that enacted internal policies which help to tackle trafficking posts? I understand, yeah.
So in response to a lot of the trafficking allegations, various companies, including Facebook and WhatsApp, have made various commitments and pledged to address these issues, but unfortunately, they really have not actually tackled the issue, which, as I mentioned, organizations such as Global Witness have actually tested whether the algorithm has been corrected. For example, ads. Facebook had promised to take tighter measures to block ads for auctioning of women or the use of trafficking on its website, and Global Witness attempted to do that after it made its commitments, and it was still able to publish various ads, literally advertising women and girls. So we had a really interesting decision in the Texas Supreme Court against Facebook for trafficking, which held that it can indeed be held liable for that. So unfortunately, I think a lot of companies, tech companies in particular, have a long way to go in terms of actually more strongly enforcing against the use of their platforms for trafficking.
Professor Hansel, do you have anything to add?
Yeah, I'd agree with that. Most of the platforms do, in fact, have policies for anti-trafficking, as well as, specific individuals and teams devoted to this issue. And I think it's one they're still grappling with, and have a lot of room for improvement, as Genevieve mentioned.
We had a little technical issue here. We were talking about tech companies and we got tech issues. Are you on remote, Professor Hansel?
Yes, I can't hear you very well. Can you hear me?
Okay. We do hear you, but the volume is really low.
Okay, my volume's turned way up. Sorry?
But you can hear us all right. Is that right? Okay, perfect. We had problem hearing you. I think, yeah, Mark Zuckerberg heard we were talking about him. The next question will be also about another billionaire. This one is about Elon Musk and Twitter and, the highlighted role of tech companies. I hope there will be no more tech issues. There has been concerns amongst human rights groups relative to Elon Musk's taking over of Twitter. He has described himself, of course, as a free speech absolutist and has been critical of Twitter policies of moderating content on the platform. The concern related to the significant danger of having so much power in the hands of one philanthropist. What do you think, Professor Hansel, Genevieve, or Sharmagh, would be, what effects, if any, do you believe his policies will have on free speech and as it relates to human rights?
Yeah, I'm happy to take that one. Okay. Is the volume okay? Okay. So I think Elon Musk has made several nods to sort of the US centric version of freedom of speech, as many understand it. Unfortunately, this does not line up with the international human rights version, which is provided by the right to freedom of expression, which is not absolute. It includes the possibility of restrictions for certain enumerated ends, including to protect the rights of others, which can be very important in content moderation. So unfortunately, marginalized communities often pay the price when platforms do not moderate their platforms, the expression on their platforms sufficiently, and it leads to self-censorship by marginalized communities, and or just abandonment and leaving the platform. So the irony is that they get less expression. their rights to expression are compromised, even though Elon Musk may think he's maximizing expression. So those are my thoughts.
Can I add on to that? Yeah, I think the point about balance is really, really important. And I think that's come up a lot during the pandemic, where we see people, really clinging to their certain rights in terms of mask mandates or vaccine mandates. And similarly, in the United States, we see this all the time with gun violence and the recent horrific massacre and what it brings up yet again in terms of the Second Amendment, where people forget often that rights exist in a balance, and one person's right, say, to freedom of speech on Twitter doesn't necessarily mean that it's absolute, because, say, the Rohingya people or the Yazidi people or any minority community also must enjoy the right to be on those platforms and not be treated with degrading, dehumanizing, hate speech, and language that can indeed and does lead to genocide and other crimes. So I think that's really fundamental to remember, that these are not absolute rights and that they must exist in a balance.
Thank you. The next question asks, it is presumed that domestic corporations in the US will have strong arguments that they cannot be held liable in suits brought under the ATS simply by participating in global supply chain in which foreign parties may have violated international law. How can, let's say, an Armenian plaintiff rebut this argument, considering that many US corporations manufactured parts of the drones, for example, that killed thousands of Armenians during the 2020 Karabakh war? I can read the question again. Professor Hansel, can you hear us?
I think I understood the facts. I mean, and unfortunately, there's no clear answer in terms of the viability of the Alien Tort Statute, but I think that it's just going to come down to, again, how close the nexus is to the US. Yeah, I mean, after Nestle, it's not looking good. So I would explore other possibilities, other statutes within the US to try to get the company on the hook. But yeah, I'm not that optimistic about the ATS at this stage.
Okay, perfect. So another question asks, what course of action should governments take to force corporations to respect human rights and avoid infringing the rights of others by complying with these respective legislations? So let's say you have a magic wand and you are, President of the United States. What type of legislation would you ask the Congress to pass for the corporations to, respect human rights? Let's assume we don't have constitution in the United States. No one wants to become a dictator.
I think more rigorous due diligence standards are really critical in that sense. Not necessarily new legislation, but even for existing legislation, internationally and domestically, I think more monitoring and evaluation of how and when companies are adhering to those standards, and obviously more serious enforcement of accountability, whatever that may be, when those violations are breached. Because often I think, a company paying a fine, when that fine means very little to them in terms of their profitability, it doesn't actually stop the issue. So I think going beyond just finding a company and taking more serious action to hold a company accountable when it does breach the existing standards, I think would be a good first step.
Professor Hansel, anything to add?
Yeah, so I still think that even if you have the CEO of a company, of a public company, who wants to do the right thing and is the most, good-hearted CEO, they're still bound by Delaware law, most likely, which prioritizes maximizing shareholder profits above all. And I think Until that duty is somehow carved out or offset, then, I mean, why would they take the legal risk of breaching a fiduciary duty in order to promote human rights or respect human rights if the two conflict? So I think that I'd love to see legislation that reconceptualizes fiduciary duties for corporations. There are many proposals out there for doing so. One that comes to mind is in the social media context. A professor named Jack Balkin at Yale has proposed that social media companies be given fiduciary duties owed to their users, the social media users, that are on par with the fiduciary duties they have to their shareholders. His proposal has been widely criticized, but I think he's thinking along the right lines. So I'd love to see more of that. And then just to answer your question, on top of that is just in general, we need more transparency with what corporate companies are doing. That's sort of step one. It's hard to really come up with intelligent solutions until we better understand what's going on, especially, you know, in the social media context with respect to advertising, which is really an opaque area. But with all companies, we need more transparency that can then inform more meaningful legislation.
Sounds great. This is about corporate responsibility, and all we were talking about was tech companies. So the next question asks to Professor Hansel, but again, Genevieve, you can answer also. This question asks, British, Russian, and other European architectural firms have been offered deals to rebuild the city of Shushi. This would include destroying a lot of residential building that Armenian people have fled, so Armenian refugees. And also this will include also destruction of a lot of Armenian medieval cemeteries, churches, and cathedrals. So the questioner asks, what legal routes could these refugees pursue, or just generally Armenians pursue, who are concerned about their medieval churches and cultural heritage sites?
That's a really hard question. These are really tricky. I mean, these are very fact-specific hypotheticals, so I feel like I'm giving unsatisfactory answers, but it's really hard to give an answer just based on a few facts, or, you know, even if I had all the facts, this is such a kind of gray area of law. It's hard to ever come up with.
Professor Hansel, that's why we have invited you. So,
I mean, you're going to want the companies to do, you know, their due diligence, their human rights due diligence, right? So you want to invoke the Ruggie principles in that regard, which are really the touchstone instrument for that, and then change course if the human rights impact assessment finds that you know, moving forward with this plan is going to infringe upon human rights. The problem, of course, is enforcement. How you would actually force the companies to do this. I think, you know, many of the strategic options I listed might help in terms of pressure points, but yeah, that's my first kind of human rights approach to that, but perhaps Genevieve has other approaches.
Yeah, absolutely. The destruction of cultural property is a really interesting area that we also, again, saw in the context of the Islamic State in Iraq and Syria, and specifically with Yazidi and Christian minority communities, where ISIL similarly sought to destroy and loot various religious and cultural areas of significance. So the fortunate part is that these crimes have actually been now extensively documented by various human rights groups on the ground and fact-finding missions. The unfortunate part is that there have yet to be any actual legal cases holding anybody responsible for those specific crimes. We haven't yet, to my knowledge, seen the use of universal jurisdiction on that basis. It's primarily been used right now, and maybe as it should be, to look more at direct perpetration of war crimes and crimes against humanity, of torture, slavery, and so on. But I think this would be a good opportunity moving forward to take destruction of cultural heritage a bit more seriously in the international sphere. And if we see, say, European courts using universal jurisdiction to identify, charge, and prosecute ISIL fighters for the destruction of cultural property of Yazidi and Christian minorities, then we might, start to see new precedents in this area going forward, which might help with this hypothetical.
Can I
Yes,
add
please.
a thought I had? So last August, there was a landmark ruling in Mosquito versus Honduras, handed down by the Inter-American Court of Human Rights. And they ruled in favor of members of the Mosquito community who sued Honduras over human rights violations, resulting from the state's failure, right, Honduras's failure, to regulate, supervise, and oversee the company's dangerous activities. It was in the fishing industry. But it was a landmark case because it started to really attribute state accountability for failing to regulate companies within its jurisdiction. And I'm hoping that's gonna become more commonplace among regional courts. So it would be, again, an uphill battle, but you might even want to pursue an action before, the European human rights system. Just given how the momentum is in this area.
Okay. Given the size of some of these corporations and the valuations of Aramco, for example, or Apple or Facebook, some of these corporations have a power and wealth more than many countries. So this topic is corporate responsibility is certainly very, very important. We will be following Professor Hansel and Genevieve in the future, given the importance of this topic. I think we are done with questions. For audience as well as the speakers here present, there will be coffees and snacks outside. Thank you very much, Professor Hansel. We would love to see you in Armenia in very near future, although Los Angeles is also a little Armenia, so this is not much different, but it's certainly better than Los Angeles. Thank you.